It's the US of A, baby, and you can sell whatever you want.
Freedom. Just kidding.
Now, there's some policies, right? Hey, this is just business. This is capitalism at its best. It is important to consider some of the ramifications of litigation, right? Litigation. If your entity, and these are patent trolls, let's just say it, this is what gave these types of companies bad reputations, is that these are companies that exist solely to threaten, settle, will actually go to court and litigate. And they're not actually making any widgets. They're not really contributing or making anything of value for the world. That doesn't sound good, okay? And so there may be some reasons to put some guardrails around those types of companies. But the truth is, inventors still benefit. Hi, I'm planning on filing a provisional patent application and have a question. I'd like to know what documents I need to include in my upload, not counting my documents, such as the government docs and such. Okay, I will have to point you to the uspto.gov. They've got a great site for basically what needs to be provided. But what I'll say is, what we tell our clients, the most important part of a provisional application is the spec, the specification. That's the written description of your invention, where you disclose and talk about what your invention is. And in a provisional, it's even more important to really explain fully what your invention could end up looking like and what you want to try to protect in terms of additional embodiments, additional versions that you might not have actually prototyped or built yet. That way, when you go to market or go to sell your product and you end up changing the materials to, let's say, metal or wood, or the shape changes considerably, but the overall functionality is the same, you'll still have protection for those, I'll call it other embodiments, other ways your invention works. So try to push yourself in the application, do your best to kind of think outside the box, not just with a one version of the invention that you've come up with. That's the best approach, I would say. And with the filing of a provisional patent application, you do get that all-important patent pending, which is important, of course, so that locks in that date to where any inventor files after that point, they will be, second to you. You'll have the first shot at getting the rights for that invention because you filed first. No longer does it matter who actually invents it first. It's a race to the patent office. Hello, guys. I keep receiving emails from trademark websites saying that someone's willing to take my trademark and register it, but I have the priority to register it first. Is this a scam? Yes. I'm currently pending with my trademark registration at the USPTO. Yeah, sounds super, super scammy. Honestly, you want to make sure that any third party, a mailer that you get, if it doesn't have the USPTO or a GOV government website, it's going to be someone looking to make money, right? A for-profit entity. And they're really, really slimy with what kind of wording they put on there about, threats or perhaps, your payment is due. We've seen lots of different formats of this. It seems to be more prevalent on the trademark side than the patent side.
Total scam. It's a very successful scam, unfortunately. So we see a lot of clients who get those letters. I get those letters from these fake law firms. And oftentimes clients ask me, like, how can attorneys do this, right? How can they, do this kind of, bait and switch? And the answer is, those aren't attorneys. No, unfortunately, these are offshore individuals who are just mining the USPTO for data and looking for opportunities to confuse folks and convince them that, their trademark is in jeopardy. So if you get anything from any outside company, not from the USPTO, not from your attorney, it's a scam, right?
Yeah.
But it's really hard for folks to kind of, even attorneys will send me emails asking, is this legit? Is this fake?
Yeah.
Yeah. It's honestly, it's more likely than not fake.
Yeah. I feel like that could be a service offering,
Totally.
Is this letter real? And then, click for a consultation.
Yeah. It's a disgrace. It's terrible. It's very frustrating, as if we didn't need any more problems at the USPTO, right?
100%. Now. Why does the U.S. allow companies to purchase patents solely for the purpose of litigation, even if there's no product associated with it? Well, it's the US of A, baby, and you can sell whatever you want.
Freedom. Just kidding.
Now, there's some policies, right? Hey, this is just business. This is capitalism at its best. Let's dig in a little bit. some policy reasons, there are some reasons to perhaps set up some boundaries. It is important to consider some of the ramifications of litigation, right? Litigation. If your entity, and these are patent trolls, let's just say it, this is what gave these types of companies bad reputations, is that these are companies that exist solely to threaten, settle, will actually go to court and litigate. And they're not actually making any widgets. They're not really contributing or making anything of value for the world. That doesn't sound good, okay? And so there may be some reasons to put some guardrails around those types of companies. But the truth is, inventors still benefit. And that is why I advocate, I think it's still a very positive thing. It's a win for the inventor. The inventor gets paid because they did all the work, research, effort it might take to develop a new product, a new thing, a new contribution to the field of art, the field of study, and their reward is financial. And so they're going to be incentivized to keep on inventing. Okay, and that's kind of one of the major policy reasons, maybe the policy reason, that the patent law was.
Yeah, I think you nailed it right on the head, JD. I think that's right. And of course, I mean, a lot of patent owners can't afford to litigate the big guys, right, who rip them off, right? They need the backing of those big law firms who are going to take it on potentially contingent fee. Or, they need that third party who's going to come in, just buy the patent, and then use their resources to litigate. So
exactly.
Either way, it serves the inventor and our society by promoting, the useful arts, right?
100%. And if we didn't allow litigation, my goodness, why get a patent to begin with? You have to enforce your rights. So I think it's challenging, but it is part of the process. I found that I wanted to name my business on the trademark registry, albeit with it pluralized. Is that it now? Does it literally mean I cannot name a business that? Does it matter that the words are registered under class 33 for wine and mine will most likely be class 25 for clothing?
Yeah, good question. So here it seems like this individual's seeking to register in the apparel class 25, and there's a registration for something almost identical in terms of the naming convention in class 33 for wine or the spirit category.
Yep.
No, I mean, absolutely not. So just because there's a registration for wine at the USPTO under a very similar name to your apparel company, that wine registration should not block your apparel application. So I wouldn't have any concerns there, but it is interesting that it's already registered in the wine category. You're trying to register it in the apparel category. I'm curious what the branding is now, right? Because that's not usually how this works. Usually, the apparel category is the one that's just chocked full of applications, and clients are asking, can I file for wine? If it's registered. So
yeah, they went the other way around.
They went the other way around on this one. But yeah, I mean, talk to a trademark attorney, have them do a formal search for you, or at least a knockout search, and they can pretty easily identify, other potential issues.
Should the U.S. taxpayer benefit from patents that are a result of government grants? Wow. Yeah. Again, another
let's do that.
Let's go for the little guy. Here's kind of my scenarios. I think a classic example is individual bootstrapping entrepreneur needs some help getting the initial prototype built for their magnetic levitation device, which requires huge to-dos, big cost, big area to do testing, right? And it happens to be the university has an interest in this type of technology. It's clean, sustainable. They've got a big lab and a bunch of students excited for it. They both, together with the professor, apply for a grant. And now the license to be able to use this invention goes back to the university. But the university carves out ability for the inventor to go commercialize it privately. That's a win. That's a win for everyone. And so I say you bet that U.S. individual taxpayer should be able to benefit in part because the government got involved, hooked up the testing, got it helped out. And the university benefits as well.
And that's pretty common too, right, JD? I mean, at the end of the day, does the United States own any patent work? Do they own any patents? Do they go around enforcing patents? I mean, your scenario sounds appropriate to mind.
I think you're right. There is a cool little hitch, though. Sometimes inventors hit on a national security, or they'll hit on a topic that the government, the Department of Defense says, you know what? We're going to actually put a secrecy order on this. Congrats on your invention. We need to make sure that the old government here is in the know before this information gets public. And so there can be, those can go on for years. Sometimes if your invention really heads on, say, communications, right? A weaponry, maybe even something more docile, that might
AI.
AI, cybersecurity, a lot of different aspects where things won't be allowed to be published. So there is kind of the purview. The government does get to put their hands in once in a while, and it really is under the guise of I want to make sure everyone's safe and not going to be exposing or publishing inventions that could put the public at risk. So other than that, it's really up to the individual to make it happen. And if they're out there hustling and they get some money from the government to do so, I think they should gain financial benefit from that. I don't have any problem with it personally. So NFL trademark expiration usage. I'm currently designing a video game using defunct teams. And I was wondering if there's anything out there that there'd be some claim of infringement for old, unused NFL teams.
Ooh, I love this question.
I know. I can't. I'm trying to think of another name of the team right now.
Yeah, I'm trying to think of like some defunct
Oilers, maybe the Houston Oilers.
Oh yeah, they're not around anymore.
Where did they go? In the 80s, a lot of weird. Well, I guess
certainly a lot of teams have moved around the country.
It was like the Redskins recently, right?
Oh yeah, right. Yeah, that was the trademark issue for years and years and years. That was like the whole scandalous trademark thing, right?
Yes.
Yeah.
What's your hunch on that? Does NFL retain rights in those now defunct?
Yeah, good question. So in order for them to actually enforce any trademark rights they'd have to have a registration at the United States Patent and Trademark Office. So that's where you should start. More likely than not, the NFL does not own these team names. It's going to be owned by the individual organization groups that own the teams themselves.
Okay.
I mean, my hunch is that these names probably are not still registered, but you're going to want to look for each one of them before you do anything about it. If they're not registered, I mean, there's still the opportunity that someone could claim that they have common law rights in the name if they're still using it for those particular products or services.
Yeah.
So I guess ultimately tread carefully, but the policy behind trademark registration and eventual abandonment is that, at some point when these trademarks abandon, you can pick them up and use them however you want, right?
Yeah, absolutely.
We want trademarks to be working for us. So if they're not being used, they're, dead weight essentially. So yeah, I follow up with an attorney, have them take a look at it. Maybe you have a list of names in mind in particular. Now, what is common in the NFL though is like logo reiteration. So logos change over time. And generally speaking, those teams keep their old registrations alive. So even if they change the logo, they're going to keep the old vintage logo alive.
Okay.
And to do so, they have to claim that they're continuing to use the trademark. So if you noticed in the last couple of years, JD, you have like throwback night.
Yeah, right. That's why?
That's part of the reason why.
Ooh, that's so good.
So good. They're not abandoning use of the trademark because they're using it maybe once or twice a year, but they're still using it.
That's so good.
So, someone like me couldn't come along and just say, hey, you've abandoned the trademark. You don't consistently use it. I can use this logo now. And then they say, no. We use it. We still, merchandise it. We sell them. They're available for sale. Our players wear them once a year, so we haven't abandoned.
That's cool. That's fun. Yeah, it makes sense now. I'm like, oh yeah, there's the retro outfits and all that. There's love it.